I'm gradually spending more time back in chambers rather than just working from home. It reminds me how lucky I am to work somewhere like this. This is Lincoln's Inn at 9:30 on a sunny August morning. Forgive the drilling and the lawnmower.
I'm Peter Dodge, and this is 11 Old Square, a predecessor set of Radcliffe Chambers where I started as a pupil in the 90s. I still work in this building today. It was designed in the Tudor style by J. Scott Aldred and completed in 1878. With the return to Chambers, I'm moving rooms and taking over a room on the first floor from somebody who was my very first pupil master, as we called them in those days. It was from the room which he had then, also on that floor, that I set out for the RCJ to attend my first hearing as a pupil, a summary judgment application before Mr. Justice Warner, sitting in the Thomas More building, in the case of Target Holdings and Redferns. Nobody seems to know quite how barristers' rooms were decorated in 1878. So, in keeping with the date and style of the building, we've decided on a William Morris wallpaper from 1876. Let's go and have a look. I'm told there's a knack to this. Oh, it's not locked. Target and Redferns is memorable for me for various reasons. As I say, this was the first hearing I saw as a pupil. It lasted, I think, 2 or 3 days, unusual for summary judgment at the time. We had to enter the RCJ from Carey Street through a temporary porter cabin. As we arrived at court, a tragic accident had just occurred. And there was a cautionary tale about returning briefs. My pupil master was otherwise engaged on the date fixed for the first hearing. He returned the brief to another member of Chambers and watched aghast as that other member then appeared, acting for the defendant firm of solicitors, all the way up to the House of Lords. Target, a lender, believed itself to have been the victim of a mortgage fraud. It sued its solicitors. At the time, many people would have categorised this as a professional negligence case. It was just one of a series of important cases involving claims by lenders against professionals arising from the property market crash of the very early 90s. Cases like Bristol and West and Mothview and Nationwide Anglia and various solicitors, both of which also involved members of Chambers with rooms on this same landing. But what Target was claiming were trust law remedies. As Lord Brown-Wilkinson, a former member of 11 Old Square, put it, this appeal raises a novel point on the liability of a trustee who commits a breach of trust to compensate beneficiaries for such breach. Is the trustee liable to compensate the beneficiary not only for losses caused by the breach, but also for losses which the beneficiary would, in any event, have suffered even if there had been no such breach? Just as fraud methodologies evolve, so do the remedies available to victims. Since Target and Redferns, trust law remedies have become increasingly important, not least because of 2 sentences in particular from the speech of Lord Brown-Wilkinson. He said, "I do not intend to cast any doubt on the fact that monies held by solicitors on client account are trust monies, or that the basic equitable principles apply to any breach of trust by solicitors. I have no doubt that until the underlying commercial transaction has been completed, the solicitor can be required to restore to client account monies wrongly paid away." Those sentences have been relied upon in recent identity fraud, home hijacking cases. They were referred to by Lord Justice Rymer in Lloyd's TSB Bank and Mark and Down and Udin, and by Lord Justice Patton in Dreamvar and Mishcon de Rea. That's the same Lord Justice Patton who, as Mr. Nicholas Patton, Queen's Counsel, I'd seen all those years ago, appearing for the plaintiff, Target Holdings, before Mr. Justice Warner. There's a link in the caption to a document in which I'll say a little bit more about Target and its facts. Increasingly often, I find that the first step in my legal analysis is to follow the money, to see through whose hands it's passed, and consider whether that person was subject to any trust obligations. And I don't just do this in cases involving property fraud. I'll do it just as much when I'm looking at, say, a failed investment scheme of whatever type. That, for me, is the lasting importance of the first hearing which I ever attended as a pupil.